All right. So good morning, good afternoon to all of you, wherever you might be. My name is Reem Al-Salem. I'm the UN Special Rapporteur on Violence Against Women. I'd like to welcome you all, participants and panelists, to this side event to the CSW 66 on gender-sensitive and child-centered judicial proceedings in custody cases, with a focus on the use of the pseudo or regressive theory of parental alienation. I'll be introducing the panelists as they take the floor, but just to say upfront that unfortunately one of our panelists, Mr. Nicolas Spejo-Jeksik, will not be able to join us, given that he had something unforeseen, but all our other panelists are hopefully here. And we hope also to have time for questions at the end of the panel. And of course, my colleagues are monitoring the chat. And so if there's any questions that arise as speakers take the floor, we're happy to deal with them. I also wanted to take this opportunity to very quickly mention the reason why we chose to have this panel discussion. So since I assumed my responsibilities as Special Rapporteur, but also before my time as a mandate holder, my predecessor, we've actually received a number of cases that have come to the attention of the mandate, many of them from Spain, but I should say not only, we've also received cases from Brazil, where women lost custody or had joint custody granted of their children granted, despite there being evidence that their fathers were being abusive either towards their children or to them. And of course, this is extremely concerning, not to mention that there are many violations of fundamental human rights that are involved. And in the majority of these cases, the concept of parental alienation or the parental alienation syndrome has been widely used by the courts when assessing these child custody cases, despite the fact that the World Health Organization excluded actually also the use of this parental alienation syndrome from its classification index. Yet it continues to either be explicitly or implicitly referenced in justice systems worldwide, with, of course, very serious implications for the human rights of women and their children. And the issue is also, of course, that despite it being, despite alienation concept being theoretically gender neutral, it is clear to us that it's very frequently used against women. So with that, I think we can get started, and I would like to first introduce our first panelist, Dr. Joanne Meyer, who is Professor of Clinical Law and Director of the National Family Violence Law Center at George Washington University in the US. Welcome, Professor Meyer. It's wonderful to have you here. And to get us started, I wanted to ask you how the pseudo theory of parental alienation manifests itself in the US, and what perhaps have been some of the trends and the consequences in the US. Over to you, Professor.
Thank you so much, Reem, and thank you so much for including me on this panel and for holding this panel, which is of such incredible importance to women worldwide. How to start? Parental alienation was invented as a means of denying mothers' allegations of child sexual abuse by fathers in custody litigation. So the syndrome was invented in that context and used very extensively in that context. It then caught on nationwide in a much looser usage of it to apply to any time a mother was resisting full shared custody or saying that a father was dangerous in any way. And at this time, my empirical study showed that parental alienation, that first of all, that custody courts across the country are very skeptical of mothers' allegations of abuse, all kinds of abuse, but especially child abuse. And what our study also found was that parental alienation cross claims by men accused of abuse were roughly doubling the rate of skepticism of mothers' allegations and roughly doubling the rate at which mothers were losing custody to the allegedly abusive father. So parental alienation is falling on very fertile ground, which is a system that does not want to believe that men are abusive in the family, and it is compounding very much that disbelief and rejection and the treatment of women who make these allegations as evil, bad parents, et cetera, et cetera. So that's sort of the big picture trend. Is there more you'd like me to go into in more depth?
Yeah, perhaps the consequences then on, well, the women, the children involved as a result of this abuse of this concept in the US.
Thank you. It's been very hard to get data on the consequences because once children are awarded into the care and custody of their abusive fathers, you cannot get, first of all, they're not safe to report what's going on because they know they'll be retaliated against. And second of all, the protective parent usually cannot get access to them, safe access to them to get reports. And thirdly, nobody believes the protective parent or the child after a finding of alienation. Children are basically permanently silenced by means of this label. They are treated as not capable of telling the truth about abuse. So it's very difficult to get the data. There are a few small, there's three sources of findings. One is anecdotal. The anecdotal reports that are all over social media and increasingly showing up in the scholarly literature are that horrible things are happening to children who are sent into the care of abusive fathers. One study by Joy Silberg and Stephanie Dallam called A Case Series of Turned Around Cases showed they looked at a small database of cases where courts had disbelieved the mothers and the children and had sent them into the care of an abusive father. And then another court fixed that and returned the child to the safe parent. And they looked at those because they were able to get real data and information from them. And they found very high rates of ongoing abuse, extreme mental health deterioration, suicidality, running away, all kinds of serious problems in school, et cetera, that resulted from these awards into abusive fathers' care. The other source of data that's far more disturbing and should be enough to be changing the world is a database of children who've been murdered by a father who was alleged to be dangerous and whom a family court refused to protect the children from. The Center for Judicial Excellence compiles this database. It's all American cases, but it's all opportunistic data collection. They just record what they find in the news. Vast majority of the murderers are fathers. Some of them are mothers. And we have not had the resources yet to do enough in-depth research to determine the role of parental alienation in those cases. But these child homicide cases are now populating every state almost. And in fact, I will talk in a minute about one particular child who's now famous thanks to federal attention to her story.
Yeah. And since you touched upon the issue of the justice system and the judicial system, so how has it been positioning itself basically on this issue in the US? Are you hopeful that there will be more rigorous attention to it, a change? How are you seeing that?
Well, the judicial system's been very, very resistant to the efforts to rein in the misuse of parental alienation. And there's been an enormous amount of legislative advocacy going on around the country. This is a matter of state law, so it has to be done state by state, locally. And every time we get something positive proposed in the legislature, the bar, the courts, and even sometimes domestic violence advocates come out against these changes. And they all have somewhat different reasons, but they all add up to the claim that judges should have discretion and that if you focus courts more on child abuse, that it might backfire against women of color. That's been one of the claims we've heard. It's been extraordinarily difficult to get more protective statutes put in place, but we are working very hard on it. at my center and many other allies around the country. The one really positive thing I wanted to share is something that was just celebrated and honored yesterday, which is that as part of the Violence Against Women Act, which was finally reauthorized after 4 long years of efforts, it was just reauthorized this week. The bill was as part of the omnibus budget bill that was signed by President Biden. In the Violence Against Women Act, which you may not have heard that much about because it has not been publicized by the mainstream domestic violence community, is a provision called Kayden's Law, named after a little 8-year-old who was brutally murdered by her father after the court refused to protect her from the father. And Kayden's Law was developed by myself and some colleagues with and introduced and shepherded through by Republican Representative Brian Fitzpatrick from Pennsylvania, where Kayden lived. And Kayden's Law specifically, it's an incentive provision for states, and it says to states that if you adopt certain protective provisions in your custody statute, then you can apply for federal funds, and the federal funds can be used and must be used to train court personnel on a long list of matters, including child abuse, which has never been a topic of training for judges in family court, in custody court. And so it's child abuse, it's parental alienation. Parental alienation is somewhat embedded. It's not explicit in these in this legislation. But anyway, it's the first time the federal government, that Congress, has adopted a law that specifically says to family courts, this is how you should be doing things, and here's some money to help you do it. And it's built around one of these terrible family court travesties, but they are horrifically common. But it's very exciting, and we were all celebrating yesterday the passage of the law and the passage specifically of Kayden's Law. So that's reason for hope. The hope is that we're going to seed interest in this around the country because it's free money, and it's free money to do the right thing. And so our job now on the ground is, as advocates and experts, is to go to the state legislatures and the courts and try to educate them on why this is important and needs to be done. I don't think the courts are interested. They're not eager to have children dead. They're not in favor of that, but they have been very resistant to believing they're doing things wrong. And so, and to even linking these dead children to mistakes of their own, like so it's, and in some ways it's not their own mistakes. In some ways it's the whole system and the whole culture and the whole kind of framework within which they're operating that lead to these terrible outcomes. And we're trying to really shift the framework along with the culture by means of this Kayden's Law.
Yeah, thank you, Joanne, and congratulations on this important victory, and hopefully more positive steps will follow that. I'll turn now the attention to our next speaker, which is Dr. Ruth, Professor Ruth Halperin Kaddari, who's former Vice President of the CEDAW Committee and Professor of Law at Bar-Ilan University in Israel. Welcome, Professor. And you've heard what Joanne just said about the situation in the US, and since we know that this is also happening in Israel, can you perhaps share a little bit about the situation in Israel? Is it the same? Is it different? In what respects? And what, according to you, would explain this phenomenon in Israel? You're on mute, Ruth.
I thought I unmuted myself, sorry. Thank you very much, Reem, and I want to join Joan in congratulating you on convening this very, very important panel, bringing this extremely difficult subject to the attention of the international community, because this, I believe, is an essential step in our fight against this use of the pseudoscientific theory, discourse, whatever, of parental alienation. So the situation in Israel, which I'll start by talking about that, is in many ways very similar to what Joan described and to what is happening, as far as we know, in so many countries all over the world. But there are also some unique facets to Israel. And the first thing that we should bear in mind is that there is no civil marriages and divorces in Israel. There's only religious marriage and divorce. And all religious laws are patriarchal and are discriminatory against women. And with respect to Jews, who compose more than 80% of the citizens and residents of Israel, the Jewish law gives absolute control and power to the men over the divorce. And for many reasons, which we don't have time to go into, the women are in much, much more need for the divorce than the men. They really cannot remarry without the divorce, while the men can remarry, and many other differences. So this really opens the way for the phenomena of extortion over the divorce. Now, on the other hand, the law used to give advantage to women, to mothers, with respect to custody and to child support, and the formal law, which actually still exists on the book, actually adopts the tender years presumption. So there is a preference for mothers, and it also puts a higher degree of responsibility for child support over the fathers. But this, in practice, has completely vanished, completely disappeared in action, in practice, in the last decade and a half. So while the discrimination over divorce still exists and extortion is a daily phenomena, the advantages that used to be with respect to custody and to child support are gone. And now the more time that the child spends with the father, the less child support the father has to hand over to the mother, which obviously works as an incentive to increase the time with the children. So this is the formal legal background over which everything that Joan described that happens in the US also happens in Israel. Plus, many things in Israel are more extreme. The fathers' rights groups, organizations are, according to our experience, are more aggressive, more violent. They even engage in international litigation. They bring some frivolous suits in the US, actually, under whatever grounds against the Supreme Court judges in Israel. It's really crazy. Then the whole culture of the maintenance of contact with both parents, with the fathers at all costs. So the culture of maintaining the connection with the fathers trumps the worry for the children's safety. And the stereotypes and biases against women, disbelief of women and disbelief of children is prevalent throughout whoever is in contact with the disputing parents. So it permeates all over, all stakeholders, welfare officers, child protection services, even guardian ad litems, and of course the judiciary. And there is no mandatory training on domestic violence, not to the courts, to family courts, and not even all social workers undergo such a training during their course of studies. And this is a huge lacuna, which on CEDAW also, and I'm sure we will hear later also from Genoveva, this is a recommendation that we kept telling countries reporting to the committee. But just as Joan said before, the judiciary is very reluctant to hear from others, to learn from others. There's disconnect between the judiciary and judicial training and the state-of-the-art research and the academics. So we're prevented from coming with our research, from talking about, the World Health Organization rejecting this theory, as you mentioned before, talking about the worldwide phenomena. In order to block the attempt to add it to the ICD of the World Health Organization, there were almost 400 experts worldwide from almost 40 countries who joined together to create the position paper, of which Joan was central in writing it, and presenting it to the World Health Organization. And the judiciary, not just in Israel, but everywhere else, is not aware of this. So just to give a little piece of data about the disbelief, the culture of disbelief in Israel, more than 75% of the cases of domestic violence are closed without proceeding to indictments. And when it comes to child sexual abuse, it's more than 90% of all complaints and cases that are being opened up, they are closed with no indictments due to so-called lack of sufficient evidence. So this is the situation which is really prone to these allegations of parental alienation.
Yeah, that's staggering numbers. And what you mentioned about the discriminatory laws, of course, is something very present in the whole region, right? Not just in Israel. And I also like the point you mentioned about the social workers, because that's something we also saw in our engagement on Spain, that of course they're very crucial in how they determine and assess whether an abuse has taken place, and their recommendations have an influence on how these cases proceed. And since Professor Kadari, you were in the CEDAW committee, may I ask, from your experience and the research that you've conducted, how would you say various international human rights mechanisms have dealt with the issue?
Yes, so may I ask Renata to put on the 2 slides that just summarize the outcome of my research. As you mentioned, I had the privilege of being 3 terms, 12 years on the committee, the CEDAW committee, and I just concluded writing a chapter on the new on the 2nd edition of the CEDAW commentary that is going to be published hopefully by the end of this year. And I wrote the chapter on Article 16, family. And here's just concise numbers of how the committee has dealt with this connection between child custody decisions that court need to take and allegations or situation of domestic violence. And as you can see, if you can look at the second bullet here, in 2014, the whole issue of situation of domestic violence and court decisions about child custody came up and was addressed only once. But then in 2016, it was addressed 4 times out of 27 sets of concluding observations. That means 27 countries that reported to the committee that year and received concluding observations from the committee. So 4 out of 27, it was dealt with. And you can see that in 2018, it was already 7 out of 23 concluding observations. So this expresses the growing awareness of the committee. But this awareness takes time, and it takes a lot of effort to get the committee members engaged in this situation. But there is a prior requirement to that. The prior requirement has to be that the state party itself should address it in its formal report, or that civil society should engage here. And this was a major obstacle that I encountered during my years on CEDAW. I actually, myself and with the aid of colleagues, we had to draw the information from civil society and to explain to civil society organizations that this is a matter for the committee to deal with. And it's not just an internal affair, it is a matter for human rights international family law. And human rights international family law has a lot to say about it. We will hear from our colleague on the Grevio. There is a special article on this issue in the Istanbul Convention, and likewise the Belém do Pará of Latin America. So civil society has to reach out to the international fora. And I just saw that we have colleagues joining us from Brazil, for example. So I know that a collective of Brazilian protective mothers had indeed submitted a major document to the committee in anticipation of the upcoming dialogue with Brazil. And this is the way to move forward. So we can see that CEDAW is now very much aware, and I do hope that it will continue to be aware of this situation and to issue the proper concluding observations. You can see an example of the text of the concluding observations. Likewise, on the issue of parental alienation, although to a lesser degree, but the committee is very firm in rejecting the theory of parental alienation in telling the state parties such as Spain, Costa Rica, New Zealand, and as I said, it's really all over the world, telling the countries to stop adhering to this theory, not to approve it in courts. But CEDAW is not the only treaty body that is whose mandate is relevant to the situation of custody disputes. Renata, if you can move on to the second slide, please. There is also the Committee on the Rights of the Child. And here, the story is completely different. So in my research, you can see that the Committee on the Rights of the Child hardly deals with issues of child custody at all. And the second bullet, you can see that out of the 87 state parties that were examined between 2014 to 2017, there was hardly ever any connection made between domestic violence and child custody, except one example that I could find is the United Arab Emirates, where it really issued a strong recommendation that pointing to the fact that women are losing custody of their children when they report domestic violence. But it's really very concerning that the sister committee that is that has the mandate to address issues of child custody is apparently unaware or not enough aware of this very, very alarming developments in all over the world. Development that I personally see this as the new frontier in the battleground of the unfortunate gender war. And there's really not enough awareness of this. And that's why, once again, this panel is really so important. And maybe it's the first step in changing this situation of unawareness. Thank you. And thank you, Renata. And we can stop sharing now.
Thank you, Professor. I completely agree with you that the committee should get more engaged. My mandate has tried to do that, and we will continue to try to do that. And I'm very happy also to hear your reference to the Convention on the Rights of the Child, because I think we forget that this also, is goes completely against the best interest of the child, which is so central. And in fact, as Dr. Joanne Meyer was talking, of course, I think, and I would like to later hear your views on this, Professor Meyer, the fact that the US has not signed the Convention on the Rights of the Child, to what extent that actually affects also the way the government deals with that.
And of CEDAW also. It hasn't joined CEDAW also.
Yeah.
No, I was just thinking when Ruth was talking that all of these things are so useful, and the US ignores it all. I mean, increasingly, I'm citing all of these instruments and findings in amicus briefs and fact sheets and various places to say the rest of the world is noticing this and paying attention to this, but the legal system has no legal need to pay attention to it because we have not joined either convention. So it's probably a measure of where the US is with regard to the rights of children. And we see that in the courts. There's no sense that children have any rights at all. In fact, their voices are silenced and treated as illegitimate.
And I'm very happy that we have a lot of people joining also from Brazil. And since in the panel, we wanted to strike a balance a bit between sort of the the global discussion, also the rights framework and how those are affected with country situations. We couldn't take on board all country situations, but I just want to assure them that since I am hopefully coming to Brazil end of May, this is one of the issues that I will definitely look at, and have also informed or will be informing the government of Brazil that this is one of the themes I will be focusing on. So moving on with our wonderful speakers, I'd like to introduce now Mrs. Genoveva Teixeira, member of the CEDAW committee and chair of the working group on gender-based violence against women. She joins us from Bulgaria. Welcome, Genoveva. It's really wonderful to have you here. And in fact, this conversation will continue from where Ruth left us off, given that given that you are in CEDAW. So I'm just wondering, how has the lack of gender-sensitive approaches to custody come up in the country reports that CEDAW deals with?
Thank you very much. Thank you very much, Madam Special Rapporteur, and I would like to congratulate all my colleagues, distinguished experts. Thank you for your invitation. This very important panel and very timely. The issue, as you mentioned, of the lack of gender-sensitive approaches to custody is in the first place raised during the consideration by the Committee of State Reports and the dialogues with the states, when monitoring, for example, compliance of the state parties with the core obligations under Article 1, 2, and 3 of the Convention, and with substantive articles like Article 5, focused on gender stereotyping and protection against gender-based violence, but also in the reporting under Article 15 and 16, as it was mentioned by Professor Kadari, about equality of women and men before the law, and equality in marriage and family relations, and also in matters concerning and related to children. Then it is further reflected, of course, in the concluding observations and recommendations to the state parties by the committee when it expressed concerns and recommendations. So further, it is explored in the case law under the offshore protocol to CEDAW, specifically in the communication procedure, when the committee finds violations of state obligations and due diligence obligations in relation to that. But specific focus on the close relation between protection of women from gender-based violence and custody is given in General Recommendation 35 from 2017, which I will mention further, updating General Recommendation 19 on gender-based violence, but also General Recommendation 33 from 2015 on access to justice, I would like to say, is of paramount importance for protection of women and children in this context. So concrete problems and concerns identified through the dialogues and alternative information, as it was mentioned, provided by the committee, also by NGOs and other institutions. So the main problems through which we actually come to the issue. Lack of legislative guarantees and mechanisms for urgent and joint protection of women and children from gender-based violence, and ensuring the best interest of the child. Also existence of provisions for mandatory mediation in cases related to domestic violence. All this expressed then in reluctance, of course, of women and fear to report violence. So therefore, I will give just examples of the recommendations of the committee in these cases. Repealing mandatory mediation requirements in divorce proceedings in cases involving domestic violence, for example, in the concluding observations to Moldova 2020. Or recommendations to scrutinize a new mediation law in Lithuania 2019. Give priority, we said, to criminal prosecution over reconciliation or mediation in the criminal proceedings in cases of domestic violence, and very important, assess the new legislation on reconciliation and mediation for an eventual negative impact on women who have been victims of domestic violence. Another problem identified, the lack of institutional guarantees and multi-sectoral cooperation and response, because it really guarantees the rights of women and children when in place. So in the case of, because we are speaking about the whole world of Ethiopia, recommendations to Ethiopia from 2019, accelerate and improve the implementation of the strategic plan for an integrated and multi-sectoral response to violence against women and children and child justice in Ethiopia. Also, in cases of lack of specialized services tailored to the needs of women and their children, and with no gender-sensitive approach, the committee recommends the establishment and specialization of such services on gender-based violence more and more, and I would say at each session from the time I've been there since 2019. Such essential recommendations under Article 5 are made, as I said, to states to all over the world, from all over the world. So recurrent issues more are the hampered and ineffective access to justice, very important in cases of gender-based violence, and gender stereotyping by institutions and also the judicial stereotyping. So discriminatory and not gender-sensitive rules about burden of proof, and weighting the opinion and interest of women and children. This is also what we notice from reports, from alternative information. So some recommendations in such cases, very recent, to Maldives in 2021, strengthen referral mechanisms to avoid communication gaps in reporting and ensure that judges, as it was said, prosecutors and police are adequately trained in gender-sensitive investigation interrogation. Discriminatory provisions and the influence of harmful and traditional practices are identified also through reporting under Article 15 and 16. And I will give an example, very recent recommendations to Senegal this February 2022, repeal all discriminatory provisions of the family code about residence of the household, responsibility for the household, prohibition of inquiries into paternity and paternal authority. They all affect women, as we know, in violence and vulnerable situations and the custody of their children. And just to mention other issues are awareness on the convention and training and awareness of the judiciary. Immediately it means that, as you said, the previous speakers, that there is no awareness about these issues which are so delicate. So we recommend in all cases strengthen the judicial system, including through the allocation of sufficient human, technical, financial resources, a regular capacity building on women's rights and gender equality for judges, prosecutors, police, for Seychelles in 2019. And also the committee addressed additional concerns when there is the issue of intersectionality in relation to discrimination, discriminative law and practices, but when they affect women specifically vulnerable, like women with disabilities, migrant women, I will mention further, from minorities, and also in all cases economically disadvantaged women. Also, as we know, always in cases of rural women, there is specific article, because they are affected in a different way and required special measures. So it is developing, and I think after what Ruth said, I think it's developing in the good science, but it takes time. But it's coming. I mean, it's already there. The problem is there, and I think we try to be the most effective possible with the other bodies with whom we are now in this platform on the mechanisms. I think I'm very hopeful that it will come further.
Excellent. And since the CEDAW committee has also dealt with particularly the case Angela González Carreño versus Spain, also if you could take a few minutes to elaborate a little bit on the jurisprudence when it comes to relationship between child custody and domestic violence, and perhaps anything about your future plans as CEDAW committee on working on this issue.
Thank you very much. Really, as I said, it is continued in the practice under the optional protocol, and there in this practice, in concrete cases, the concrete obligations, state obligations, and due diligence obligations of the states are elaborated further by the committee. And I will say that the views also summarize the views of the committee, the main principles of protection. Explicitly, I will mention first General Recommendation 35, what it says, because it's based on the central concepts expressed in this case law that I will mention also. So the rights or claims of perpetrators or alleged perpetrators during and after judicial proceedings, including with respect to property, privacy, child custody, access, contact and visitation should be determined in the light of women's and children's human rights to life and physical, sexual, psychological integrity, and guided by the principle of the best interests of the child. So this is central also for the case you mentioned, Gonzalez Carreño, but also other cases, because it's interesting that I will mention them as well. So concerned by the lack of special protection of women and children and their ineffective access to justice, their exposure, as I said, to stereotyped attitudes, including by the court, the committee recommends, among others, in its views in other cases that I will mention, because it's important that it's a body, let's say, of principles, to adopt measures to ensure consideration of the child's best interest in custody decisions, J.I. versus Finland, to ensure that victims of domestic violence and their children are provided with prompt and adequate support, including shelter and psychological support, SL versus Bulgaria. So in the case Gonzalez Carreño, the committee notes that the history of gender violence must be taken into account in child custody and visitation proceedings in order not to place gender violence victims and their children in danger. Because instead, what it was done by the authorities in this case, that the Spanish judiciary applied stereotype notions of the nature and seriousness of gender violence in deciding visitation schedules. So in this case, as you know, and also most of those interested in the practice of the CEDAW committee, is an important case. The daughter of the author was killed by her father during visitation, which was granted to him by state institutions. As a result also of the underestimation of the gender-based violence and the risk factors related to the father himself. But further recommendations in other cases to consider the child's best interests as primary consideration in all actions or decisions that concern him or her, both in the public and private sphere, and that is reflected both as a substantive right and as a rule of procedure. M.W. versus Denmark. It's a not very known case, but I thought it was important to mention because it's also concerned a migrant woman. And compound stereotyping, judicial gender stereotyping against her. Also, according to and applying General Recommendation 33, in one of the cases, G.I. versus Finland, the committee notes that often judges adopt rigid standards about what they consider to be appropriate behavior for women and penalize those who do not conform to these stereotypes. And based on that, they decided in that case also the case J.I. versus Finland at the national level. And the recommendation is in cases of domestic violence against women and children, there is need for addressing specifically credibility and weight to be given to women's voices, arguments, and testimony. Same for the children's voices, of course. It's also in X and Y versus Georgia, we have discriminatory attitudes in favor of the aggressor's evidence, disregarding the evidence given by the woman in violence. And concerning specifically parental alienation, I will mention because in the case SL versus Bulgaria, it explicitly discussed, the court accepted in the Bulgarian case at national level that the social worker's standpoint that the mother had influenced the children, burdening them with her own negative attitude towards the abusive father. And from there, also the assumption, the wrong assumption of the court, the domestic violence court in this case, considered that the violent acts of the father were a defensive reaction provoked by the behavior of the mother who turned her sons against their father. In this case, the court found that the parental alienation seen in the child towards his father was caused by the mother, who should have maintained a positive attitude despite the violence towards the father, given that there were no reasons really for a minor child to become hostile against his father without having been aggressed specifically by him. So on the other recommendations, combat all negative attitudes, as I mentioned, and stereotypes, also in M.W. versus Denmark, but here also there is against women, especially mothers of foreign nationality and their children, to ensure that women victims, survivors of domestic violence, including migrant women, have effective access to justice same case of discrimination and stereotyping of the woman is in Aisha Tujalo versus Bulgaria, another case of a migrant woman. And ensure training programs for judges, prosecutors, and lawyers, specifically it is set in MW versus Denmark, involved in administrative and judicial proceedings and on the dynamics of violence against women, custody and visitation rights, and the best interest of the child principle. So we have basis, and I would say that CEDAW committee addresses systematically this issue, as we can see also when I research, I saw in all the work in methods, and it's a good basis for further work. And hopefully, as I said, in the platform, and hopefully more contacting, now I'm hearing also from Professor Kadari with the Child's Rights Committee. I think this should be the next step, absolutely, because it's really alerting that these issues are not, not perceived like common, because we perceive them as common. And also in view of, I will say, that there will be, the procedures will be more and more harmonized at the UN level. And the first committee with whom, let's say, with them we will harmonize is the Child's Rights Committee. So hopefully there will be a future. Thank you.
Thank you, Genevieve. Just listening to you, it becomes clear that CEDAW has dealt with this extensively, and there's a lot of findings and recommendations pertaining to a number of countries. I think it might be useful to perhaps make that very clear on your website and just provide links to, you know, the reports that you've just mentioned. And it's very clear that there are recurring findings coming out and recommendations, particularly to how the justice system should be dealing with these cases, and the need for training and the need to center also cases on the best interest of the child and so on and so forth. So that would be my little small recommendation also in order to share more information about this issue. And going now from the global to the regional, I'm very happy that we have with us also Mrs. Iris El-Warasi, President of the Group of Experts on Action Against Violence Against Women and Domestic Violence, GREVIO. Welcome, Iris. It's also wonderful to have you here. And perhaps as you were listening, the different mechanisms have dealt with it better or worse, depending on where they sit. But it also seems that GREVIO has been aware of the use of this pseudo theory in a number of countries that are signatory to the Istanbul Convention, which obviously GREVIO also monitors. So in what way does GREVIO address this in its review of the convention's implementation?
Indeed, dear Rim, GREVIO has come across this concept in its monitoring of the implementation of the Istanbul Convention, and our forthcoming third report on GREVIO activities is going to devote its focus section to the issue of domestic violence and child custody and visitation rights, listing all GREVIO's findings in this area, including the use of the so-called parental alienation syndrome as a way of minimizing the risk of domestic violence in family court processes. So we are looking at this issue because one of the articles of the Istanbul Convention, as it was mentioned before from the professor, in the Article 31, it is being required from the states to ensure that in the determination of custody and visitation rights of children, incidents of violence covered by the scope of this convention are taken into account, and that the exercise of any visitation or custody rights does not jeopardize the rights and safety of the victim or children. The drafters of the convention were very aware that child contact can be an area of ongoing psychological, emotional, and physical abuse of women and children. However, despite this obligation, GREVIO has observed shortcomings in all parties to the convention, and this includes the failure to regard child witnesses of domestic violence as victims, the failure to take incidents of domestic violence into account in court decision on custody and visitation rights, or the inappropriate use of mediation, inadequate risk assessment, leaving the real risk to women and children unrecognized. This is coupled in some countries with the widespread notion among relevant professionals that women, victims of domestic violence who are concerned for their safety or that of their children, may be manipulating their children. So that will bring alienating them from the other parent. So research has found that claims of parental alienation were used to negate allegation of domestic and sexual abuse, as it was said from the previous speakers. And allegations of domestic abuse can even be used against women as evidence of parental alienation. That's why this has prompted Grevio to address the use of the so-called principle of parental alienation syndrome by state authorities in the report on France in 2019, followed by the reports in Andorra, Belgium, Italy, Spain, and Poland. And I would like to stress, however, that this issue, as it has been told here, it is not unique to Europe, and other women's rights mechanism and treaty bodies and you as UN Special Rapporteur's mandate have addressed this issue, and I'm so happy that this side event, it was dedicated to this particular and very useful issue. Because in 2019, the platform also of the independent regional and global expert bodies on discrimination and violence against women, over which I have the honor to preside this year, also issued a statement to call attention to this.
Absolutely, Iris. And perhaps this is also the right moment to say that it's my intention also to focus one of the thematic reports during my 3-year mandate on this issue of the lack of gender-sensitive and child-centered judicial processes, including the parental alienation application. And that's because obviously since our engagement on Spain, I've had an avalanche of cases, but as our listeners might know or not, the mandate's capacities is very, very small, so it will not be possible to deal with every individual case. That is why also the mandate would like to deal with this more from a sort of a global perspective. So then how, I mean, has Grevio issued then, yeah, you mentioned that, right? You've also had very specific findings. I don't know if you want to elaborate a bit more on that, but I'm interested to hear actually what the state reaction has been to these findings. Have you found receptivity among states where you've indicated that in the reports? Have you seen any significant adjustment, you know, of the gaps and the problems that you've pointed to the extent that you can speak to this? Yeah.
Mm-hmm. Yeah, of course, Grevio has discussed the issue in several reports and issues findings. Mm-hmm. For example, as I said earlier, in relation to France, and it highlighted judicial inadequacies in addressing domestic mm-hmm. violence, because it noted that expert reports on the mental health status of children in this proceeding were entrusted to psychiatrists not specifically trained on domestic violence and its traumatic consequences on child witnesses. So this resulted in the suffering of children going unnoticed, in secondary victimization of victims, or in psychologists attributing the psychological state of children to parental alienation syndrome. So that's why Grevio strongly encouraged the French authorities to increase the level of training on domestic violence and other forms of violence. In relation to Spain that you mentioned in your question, Grevio also noted with concern that the official dictionary of the Royal Academy of Medicine included parental alienation syndrome as a form of child abuse, but that this was under review at the time. Mm-hmm. So our report on Spain clearly states that the notion of parental alienation allows intimate partner violence and the resulting safety risks for women and children to remain unaddressed, leading to harmful consequences, including death. On a positive note, the report of Grevio in Spain welcomes the guidelines that were issued by the General Council on the judiciary to all judges in Spain, drawing their attention to the lack of scientific basis for concepts such as parental alienation, but noted that this had not led to a change in judicial practice throughout the country. And we also have it as an issue in our report on Italy. Grevio urged the Italian authorities to ban the use of concepts related to parental alienation by court-appointed experts and social workers, as well as any other approach or principle, which tend to consider mothers who invoke the violence as uncooperative and unfit as a parent, and to blame them for the poor relationship between a violent parent and his children. A very similar finding was also made in relation to our report in Poland, where Grevio called on the authorities to refrain from the use of this concept. So, as you can see, Grevio adapts its finding to the situation and also to the specific of the countries, calling for more training of professionals, expressing concern or calling for an outright ban of this pseudo theory.
Thank you very much. That's very useful to know about the situation in Europe, but also your efforts on this. Given that we have now reached the end of the speakers list, I wanted to circle back to all of you as you've been listening to each other to see if you have any comments or interventions or anything you'd like to add. So I'd like to start off with Professor Joan Meyer. The floor is yours.
Thank you. It's been wonderful listening to everyone, although I will admit to feeling a little bit on the outside because the US is so not linked in to any of these international instruments and procedures. But one thing that keeps coming up, and it's been controversial in the US, I'd like people's reactions to the issue of training, specifically training judges in particular, because that is a key element of Kayden's Law, which is now an incentive provision that we now have adopted. And it was bitterly opposed by a number of judges and some advocates who aligned with the judges as inappropriate for there to be any legislating of how judges should be trained. And there is also the question of whether training really makes a difference, because if the root of this problem is really discrimination and or misogyny and an unwillingness to see the abuse of women and children by men, is training going to change that? So I would be very interested in everyone else's perspectives on both of those questions of whether you face hurdles in getting courts to accept training and whether you think training is capable of really making a difference.
I'm actually very glad, Professor, that you mentioned this, because it's my understanding that in other countries, including the one that we dealt with, yes, there's this hesitancy even to make such recommendations to the judiciary, given the separation of powers, right? And the concern that maybe if the political branch or any other branch sort of says that, you know, that it's an interference in the work of the judges. So, so yes, that would also be my question. Like, is there any other way around that? I'm not a judge. I haven't practiced law, but I would imagine there are certain sort of regulations around, you know, the ability to practice, to be just and fair and to take decisions in an upholding justice and in an impartial manner. So I don't know if there's other ways one can sort of make the point or not force, but yes, actually bring about changes that are binding when it comes to the judiciary. So that would be my question. Coming to, yeah, please,
Professor. Just address the separation of powers issue, because we've been actually working on that and researching that in various states, and it's not clearly preclusive of legislative mandates for training. In fact, there are state laws requiring different degrees of domestic violence and other kinds of training for judges. It is something judges invoke all the time, as though it is an absolute bar. It is not, but it is kind of amorphous, and it is the concern, absolutely.
Yeah. Professor Ruth.
Yes, thank you. So I would like to address two issues. Maybe I'll start with the question of judicial training, which I also mentioned in the first round. So as we also heard from Genoveva, this is a recurring recommendation given practically to all state parties, and it is in General Recommendation 35 on violence against women, and also General Recommendation, I think it's 33, or I'm not sure about the number, about access to justice. And yet there is this resistance. It's not only the resistance for mandatory training. In many jurisdictions, and in Israel in particular, we also face resistance of opening up the courts and transparency, or rather lack of transparency, in publication of judgments due to obvious concerns of privacy, especially when children are involved. So, sorry, the court administration is very quick to prefer these privacy concerns over the need to have the ability to scrutinize the system. So we, and here I'm talking about the academia and also activists, because I'm also heading a center in my university, which is kind of a combination of academic and activist center. We are really unable to actually know what's going on in the courts, because all the proceedings of family proceedings are held in camera, behind closed doors, and the decisions do not get published. Obviously, the welfare reports do not get published. So there is actually no way of proving to the system that it is at fault. And it's only, it's really admirable by some other jurisdictions. And I just saw recently a report from Sweden where the judiciary, the Ministry of Justice, actually examined itself and conducted an internal examination of court decisions. Same was in the UK and in some other jurisdictions, where they actually could see how the system really does not protect, or the opposite of protect children, and really is not taking care of children's safety. Maybe what we should think about, and this is also for you as the special rapporteur, special mandate holder, is to combine efforts with other special rapporteurs and mandate holders on the impartiality of the judiciary. And maybe if it would come from such a position, and also with some allies, because there are some judges who also agree that there is a need, who are aware of the problem. So maybe we could turn these allies from within and be more successful in convincing. Now, I just also want to relate to the data from CEDAW. And here, Renata, can I ask you to share once again the last slide in the document that I sent you? Because this is going to be a bit of maybe downplaying the expectations, but really not to discourage, but only to have everybody aware that proceedings within treaty bodies under the optional protocol, when the treaty body is acting as a quasi-judiciary judicial forum, these proceedings are hard. They are hard. They really require tremendous amount of resources, and they take a long time. And this data, Renata, proceed to the last slide. Or maybe you just took the first two. More. Yeah, here, thank you. So out of the 37 cases that were brought to CEDAW in the last decade, between 2011 and 2020, 37 dealt with Article 16, the article on equality in family relations. So 13, which is really a third, actually dealt with child custody, which demonstrates what I said before, that this is the frontier. This is really the front line of the battle between the gender war. But and all of them demonstrated the same pattern of continuous domestic violence after parental separation, where abusive men use their rights to custody and contact with the children as a means to maintain control. It's coercive control that proceeds after separation to continue committing further violence against their partners and their children. But only 5 were decided in favor of the mothers, of the authors. Only 5 out of these 13. And the reasons for most of the others were deemed inadmissible for various reasons, which are really legalistic reasons. So we need to be aware of this. The committee, it has limited resources. It is not a fact-finding forum. And when the facts are not substantiated enough, and there's really no way of finding out, when the representation, sometimes the legal representation is really less than adequate. So it's we just need to be aware that on the one hand, we need people to come to these mechanisms, but when women do that, when people do that, they really have to get the best representation, the best help, maybe by international NGOs possible, so that the cases can really proceed appropriately. And then the rest of the cases, as I wrote here, which were deemed inadmissible, they all demonstrated the same pattern of parental alienation. So the problem is huge. We need more resources to properly address it. Thank you, Renata.
Absolutely, and perhaps just a comment that on our engagement on Spain, in fact, it was not just the mandate that intervened. We tried to also, and it was not difficult, galvanize support from among the procedures. So there was the working group on discrimination against women and girls that joined, and also the special rapporteur on torture, which I think is very telling, right? To say that the alleged acts that occurred amount, in their effect could amount to torture. And I believe also the special rapporteur on health had also joined various of these communications. But I take your point. We do have a special procedure dealing also with the judiciary, and it's definitely something to consider. Okay, then I would like to also give the floor to Genoveva, if you have any comments you'd like to share.
Thank you. I just would like to say about that we also have obstacles with this when we recommend, for example, mandatory training for the judiciary based on CEDAW, which is, let's say, ratified and also prevails upon even national legislation according to the national system of these states. Sometimes we receive in a follow-up procedure, for example, this last session, that the judiciary, of course, they will implement this mandatory training, which was on gender-based violence, different forms, which was recommended as a priority recommendation to the state for the 2 years period after that. But then there were these arguments, as you said, that they say that they are independent, and the state says the government, it cannot be fully implemented, it cannot be implemented until the judiciary decides itself. Here, for me, comes the issue of, when the convention prevails, so the training on the convention, the training on gender-based violence, which is also part of the convention, which is severe form of discrimination. Also, it's the answer that they are independent, also, as you said, should be challenged, because specifically in the case of CEDAW, I would say more grievous, and to think that they are really obliged. I mean, there were cases when our judges here, even the Supreme Court, Administrative Court, once said in one decision, of course you say this convention, but we are not bound with this convention. The government, yes, but we are not bound. And this is something that we have to attack, because it's actually the whole system and the whole state. They are part of the state system. So they are not autonomous republic in the state. So it's also valid also for other countries. It's something that we have to discuss. Then I think that general prevention, general addressing masculinities, addressing machismo and other patterns, addressing of course, equality education, which was something in the last years we know such a backlash. I think this is also one of the reasons. It comes together. Without the general awareness cannot be done. And also from what Iris said, I see, so it goes, it's so pervasive that it goes beyond any standard. So let's see how, with standard that with the standard setting by, let's say, UN treaty bodies, how to deal with that really collectively. And concerning the training, later we will speak about, maybe as you know, we have the Women's Human Rights Training Institute. We are having it since 2004. And really there are results, as you said, when people learn about the material issues and learn about the procedure. And many cases now that I see under the optional protocol are from our students. So it means that once it passes through them as a course, and I think we have to continue, despite the pandemic and after the pandemic now, in this situation, to continue educating lawyers for women to have, as you said, legal aid, support, whatever the outcome at the level of, let's say, the committee or other committees under the protocols. Thank you.
Thank you, Genoveva. That was very useful. Moving to you now, Iris, if you have any comments or remarks.
Yeah, just to clarify for the audience, because here at the Council of Europe, we have a two-step monitoring mechanism. It is GREVIO. It is composed from independent experts that are being helped from the Secretariat of GREVIO on doing the baseline evaluation. And there is also the Committee of the Parties. And the Committee of the Parties is following the implementation of our recommendations in respect to the countries that have been mentioned. And so we will see when these countries report back to the Committee of the Parties, and which will be the conclusion. But I should say that in our monitoring activity to date, we have described at length, and we have brought to light state parties' strengths and also weaknesses in the implementation of the Articles 26, 31, and 45. That are concerned for the victims of domestic violence and decisions that are made on custody and visitation rights. So in our baseline evaluation reports that have been published so far, it can be seen that while concrete steps have been taken by all state parties in this regard, the road ahead is long and implementation is inconsistent, with too many victims being failed by state authorities. So it is also clear that there are positive signs of improvement, which in some cases has been as a direct result of GREVIO's intervention and our monitoring work. And this demonstrates not only the enduring purpose of the monitoring process, but also the value in GREVIO's consistent identification and, where relevant, repetition of the steps that need to be taken to improve the situation for victims of domestic abuse in order to further reaffirm the rights and dignity of the victims of domestic violence that are guaranteed under the Istanbul Convention. So, to that end, we might say that as GREVIO, we have identified cross-cutting actions that all state authorities should take in order to achieve continued progress on improving the situation for victims of domestic violence in relation to custody and visitation rights, notably 12. And we have ensured that relevant professionals are informed of the absence of scientific ground for the parental alienation syndrome and the use of the notion of parental alienation in the context of domestic violence against women to overshadow the violence and control exerted by abusive men over women and their children and their perpetuation through child contact. GREVIO's finding in the issue of domestic violence and child custody and visitation rights see that as a way of minimizing the risk of domestic violence in family court processes. And as I mentioned before, especially the Article 31 it states very clearly that it requires from the states to ensure that in the determination of custody and visitation rights of children, incidents of violence covered by the scope of the convention are taken into account, and the exercise of any visitation or custody rights does not jeopardize the rights and safety of the victim or children. So that's why, for example, one of our recommendations, as I said earlier in French, it was also to encourage the French authorities to increase the level of training on domestic violence and other forms of violence, because one of the principles of the convention is the continuous training of family judges. Just to, in order to respond to the question of Professor Meyer. So we don't think that this is giving you the solutions, but it's part of a solution.
Thank you, Iris. Very helpful. I see there's been also a couple of questions that have come in the chat, and since we have some time left, I will proceed to pose these questions. So there was one question about which says, where can we see the training which the Women's House Rights Training Institute has developed, including on a DVD, custody and alienation? I don't know who would be able to take that question.
Who did it say developed the training?
Women's Human Rights Training Institute. Was that you, Genoveva?
I think it was Genoveva who mentioned it.
Yes. Yeah. It's an initiative. It's a program of our organization, the Bulgarian Gender Research Foundation, and partners. The Center for Reproductive Rights was our partner, still partnering with lecturers. It's mainly for lawyers from Europe and Eastern Europe, but we broadened it in a way. We are having also participants, lawyers from other continents. It's 1 or 2 each time we can add. And it's a program that actually, if you would like, we can maybe through the special rapporteur, as we already started speaking about that, we can you can put announcement, and for example, as a result of this meeting, in order for you to find it easier. Even if it's not from the region, we also have observers under specific conditions, but it's a really very specific theory and practice. It turned out to be very, very important for developing the legislation, monitoring by young lawyers, and cases before CEDAW, mainly CEDAW, but also before under procedures, other treaty bodies, and especially European Court of Human Rights also. So we had about until now 140 students since 2004, also men. So we have lawyers also participating, but it's something that we will discuss. We will have a next session of a current course that I wanted exactly maybe after that to speak with you, with the participants in the platform, that to invite you, because we had 2 sessions online because of pandemic, but now we would like in presence, like we were organizing before. People want to meet here in the region, especially. Thank you. So.
Thank you. And another question I see to Professor Meyer. First, it comes from Susan Oldweiler. First, thank you for all you do. The need to educate at a state level was mentioned regarding VAWA and Kayden law, i.e. federal funds/training. Is there a recommendation on how we can best help with this educational initiative locally in our state?
Thank you. That's a wonderful question. The National Safe Parents Coalition is providing lectures and some education and training on exactly that question. The first such meeting, I think, was Tuesday night. I don't know if it was recorded, but look for the National Safe Parent Coalition on Google and you will see some reference to that, and there will be continued trainings. We have to work out the federal government and the advocates need to work out sort of how that funding is going to work. So we're working on the technical details of that, but the key steps that have to be pursued at the state level are going to be to get your courts and your lawmakers interested in doing this. And as we've been discussing, bringing the courts around is going to be a taller order than bringing the lawmakers around. But there are, as someone else mentioned, some very good devoted judges who know it's necessary and who will support it. So I would advise any advocate on the ground to link with your other protected parent advocates and hopefully domestic violence advocates as well to start strategizing how to help the state legislature to adopt the provisions. There's a number of provisions that are required, and it's a bit of a heavy lift. So start looking at those specifics, start seeing if you can build a coalition to support the adoption of those provisions. And in the meantime, we'll be figuring out how exactly the money can be applied for. But everything needs to be legislated first.
Mm-hmm. Great. I see there was a question also to the mandate about how to contribute to the report. So you can find me on Twitter. We have a website also for the mandate, and we will announce when there is a call for input like we do ahead of any report. So please look out for that. It would not be, the report would not be before next year. So for the June session of the of the Human Rights Council. And also what we normally do is there will be an expert sort of consultation. And for this particular topic, I think it will be necessary. So hopefully that's another way also to provide input. There was also a question earlier on that we didn't take and that I would like to take, which is about the formal definition of parental alienation. And there are, of course, theorists who tried to come up with a scientific definition in the context of the parental alienation syndrome. But in this panel, we're looking actually at the not so much the syndrome, but more also the concept of parental alienation, which describes this loose set of concepts that are used to describe a child's rejection of a parent as a result of the manipulation by the other. And frankly, we shouldn't be seeking a formal definition since it's not based in good science. And as we said, the WHO has rejected it. So this is how we can describe it in broad terms to refer to how the justice system or others are trying to mobilize the use of the concept. I don't know if anyone else from the panelists wants to also complement to that point in terms of definitions or not.
I'm happy to, but I see Ruth moving to unmute herself.
Go first.
Go ahead, Professor.
I just wanted to say that it's a little bit like a game of whack-a-mole. I think the US folks know that game. I'm not sure if the rest of you do. It's a game that's often on a boardwalk where you try to pound down the mole and then it pops up somewhere else. Anyway, it is very much like that. Every time we manage to discredit PAS, we get PA. We discredit PA, now we have gatekeeping. We discredit gatekeeping, and now it's child resistance and refusal. So child resistance and refusal, the label is supposed to be neutral as to origin. Mm-hmm. It's supposed to allow for anyone to explain that the child's resisting for perfectly legitimate reasons. But insofar as it's really the inheritor of the whole alienation framework and approach, it tends to be used by people who still believe and look at things that way, and tends to be used that way in court. I have yet to see a court proceeding where child resistance and refusal was discussed as being caused by the parent they were resisting, and just addressing that parent instead of blaming the preferred parent. There's the latest iteration of this is now to talk about hybrid cases, where the idea is that experts should examine every possible reason why a child may be resisting, and they should give a beautifully analyzed and mapped out discussion of all the different reasons and the percentage of impact that these different reasons have on the child. And the theory is that that will be accurate, and then the court will know exactly how to craft its intervention. To me, you can tell from my tone of voice, it's an absurd idea that any expert's going to be able to analyze that accurately, or that an intervention can be crafted that perfectly mirrors these things. And in fact, even a child or even an adult cannot perfectly describe all the reasons why they feel hostility to one person. So it's an absurd idea, but it's also one that really enables and covers up abuse. It enables the covering up of abuse because it allows experts and deniers to say, well, yeah, there was abuse, but there's all these other reasons, and these are the ones you should focus on. And so I find the hybrid or the multifactorial, which is another word for it, the multifactorial approach to be in some ways even more pernicious than the original idea of alienation.
So
Professor Ruth, yes.
Yes, thank you. What I wanted to add is that I think we haven't talked enough about other stakeholders in this problematic arena, which is the experts, or so-called experts, or self-proclaimed experts, and to acknowledge that there's a huge amount of money involved in this cottage industry of parental alienation experts who really offer a magical solution to courts which are overburdened, overloaded all over the world. And there are real structural problems here. So it's not that the judges are God forbid, with evil intentions, but they find themselves really helpless. And some of them do not have enough knowledge because of, as we already indicated, the lack of sufficient judicial training. And here come these self-proclaimed experts and promise that they can fix everything very, very easily and without all those litigious lawyers who ruin everything. And so it's very tempting to buy into that, and add to that also not just the biased and based on stereotypes disbelief of women, but also the lack of the willingness to believe that the levels of violence in our society and that the levels of violence against children in our society are so high. It's really difficult to accept this reality. So we really have very, very high obstacles here to overcome. And I think that we have to acknowledge that there is a crisis in family courts all over the world. It's and the solution, and so parental alienation is really at the top of the iceberg, but the iceberg is much larger than what we managed to cover here. But it's really a first step in the direction, I think, I hope, of dealing with it.
Absolutely. Since we're coming up to the end of our session, I'll just take one more question, and that is dedicated to CEDAW. So there was a question, sorry, let me see. Yeah. Does CEDAW have any plans to address this issue with state parties that have ratified the treaty, and to request that this issue be addressed and that appropriate laws prohibiting the use of alienation be adopted? This is from Dimitra. Genoveva, do you want to take that?
Yes, thank you. First of all, thank you very much. That would be very good. I mean, because we have 189 state parties, so let's say close to the majority, let's say, of it's majority, but close to all states members of the UN. But it's when we started with we come to the issue through reporting, when we have information about. And what is also important that, as Professor Kadari said, the higher level of suspicion from our side when looking at the issues. And we have now also, from what they did in CEDAW, herself and her colleagues, and also we are communicating, we really started having, and colleagues, high level of suspicion. Each and every state report, we are looking now through also this lens. And the more we have alternative information, additional information, parallel from other bodies, treaty bodies, it would be good. So it's very important also for civil society to provide information reliable on these issues, and also, let's say, to hope that we will return to the normal interaction of our committee with the NGOs providing alternative information. Now it's in writing, but there were limitations, as you know. So we are more than willing to come to normal and to have, prior to the dialogues, to have the full information. But let's say, and now developing also these concepts through the special rapporteur and the whole platform that will be in touch, and hopefully information will go to the committee. And I promise that we will do our best to be very suspicious and to recommend really very important measures and tailored to each and every situation, as I said, but they're very close, not only general recommendations, but important in order really, as states say, to be concrete enough and to follow, maybe to put them in the follow-up, let's say, to have reporting. Thank you.
Wonderful. Thank you so much. I wanted to acknowledge the question that's been lingering about whether there will be a transcript. So yes, the team generates a transcript, but it might not be, great to, I don't know how user-friendly it is, but we'll look into this and get back to you. And I'm not going to pretend to summarize this very rich discussion that we just had, but I've noted some of the recommendations that came through, and I'll just quickly mention them, which is to work on the involvement and really taking this up by the Committee on the Rights of the Child. There was the issue of training for the justice. There was the issue of mandatory trainings that are often recommended by CEDAW committee, but there is resistance on the ground by the justice system in some countries arguing on the independence. So there was a recommendation to train on the convention also, the CEDAW, and how to use it, given that countries are bound by it. The issue of collecting data, which also came out very strongly in Professor Meyer's presentation, and that we need additional research on this phenomena, additional documentation, and the need for transparent publication of judgments of family proceedings to scrutinize the system, which Professor Ruth referred to. And then also by Professor Ruth, there was a request for stronger collaboration among special procedures, but also targeting more also the procedures that deal with the judges and the impartiality of the judges. And also the need for specialized legal support for victims to bring this forward, and also need to train students, educate lawyers so women can have a good legal support. And finally, here I have the need to raise awareness for prevention, addressing misogyny, patriarchy, toxic masculinity. I'm sure there are others that I forgot to mention, but I really want to thank our wonderful and knowledgeable panelists for a very inspiring and detailed discussions. Hopefully this is, as I think Iris mentioned, the first of many more combined and collective efforts to come. I also want to thank our wonderful participants who stayed throughout the hour and a half and have been very active in the discussion. So with that, thank you all, and I wish you a good morning, afternoon, evening, wherever you may be. Bye-bye.